Good morning or good afternoon, depending on where you are. Welcome. We have the jury conference.
Hi everyone, Mark Barden here at Sandy Hook Promise.
Oops.
On December 14th, 2012, my 7-year-old son Daniel was shot to death in his first grade classroom at Sandy Hook Elementary School.
Just a
We were
sec.
shot and killed
Something is not working.
individuals in about 4 minutes using an AR-15 military-style assault rifle. There is no place, there's no need.
Okay, sorry about that. Okay, we have a short day. Oops, something's not muted. Okay, sorry about that. We've got a short day. Looks like about 2 hours. Jury conference, and tomorrow we'll be closing arguments, and that'll be good. I'm ready for this one to be over. We have the Rust trial, which started, and we'll be doing that one tomorrow during the jury deliberations. And without further ado, let's get started.
Attorney Manning, should we wait for Attorney
If we
McGinnis?
can, Your Honor, he's just right outside.
Thank you. Yeah, if you would, please. I thought I had it. This morning is scheduled for what has been called the charge conference. Now, historically, in the state of Connecticut, charge conferences in criminal matters were held in chambers. They were not public. There was no record. That is, there was no court reporter or court monitor recording the proceedings in chambers. A number of years ago, that changed, whereby charge conferences are now on the record. However, in this case, there has never been a charge conference in the state of Connecticut that has been live streamed. What the court will do first is just indicate how this conference will proceed. The court has given to each side its proposed jury instructions. Those instructions essentially are standard instructions from the Connecticut Judicial Branch Criminal Jury Instruction Manual. The parties have given to the court their proposed jury instructions. What the court does not intend to do is go through every jury instruction word by word and elicit comment. What the court first will do is ask counsel to comment on certain instructions. Then we will take a recess. Counsel will have a more full opportunity to review the court's proposed instructions, and then we will reconvene. So the first instructions that the court would like counsel to discuss are these: a consciousness of guilt instruction, a third-party culpability instruction, hindsight bias instruction, evidence of presumptive blood test instruction, and an instruction on motive. The revised version of what the court has given to counsel this morning includes instructions that were not heretofore included in the original draft, the first draft. That is, the court has included an instruction on accessory liability. The court has included an instruction on expert testimony, and the court has included an instruction on stipulation. Those instructions were not included in the original draft. So to begin, court would hear from counsel on an instruction which the court did not include in its draft, the instruction on consciousness of guilt. And the court would defer to Attorney McGinnis.
Yes, Your Honor. Good morning, and may it please the court. I think we had discussed the counsel can sit down.
Yes.
Okay. All right. Yes, Your Honor, we are requesting the consciousness of guilt instruction, which is in the state's proposed instructions. It can be found on page 13, Your Honor, paragraph 6, or enumerated paragraph 6, I should say. And Your Honor, essentially, we're relying on State versus Pascal 109 Con App 55, 70 to 74. It's a 2008 case with respect to false statements that we allege were made by the defendant during the course of the interviews. The instruction itself is fairly standard, and I think we've sort of indicated to the jury that unless they find that the alleged fabrications and destruction of evidence was related to the act of the actual alleged charges, then they shouldn't be making a finding that it shows a consciousness of guilt. So we think it's written in a very balanced way. One of the issues that we take with the defendant's proposed instruction on consciousness of guilt is that it's essentially attempting to marshal the evidence, which seems to be something that is common in a lot of their requests, that they're asking the court to sort of marshal evidence for them and engage in closing arguments. So what we've done is simply identify the evidence which we believe demonstrates a consciousness of guilt, and we're asking the court to instruct them that unless they make certain findings, they shouldn't consider it as consciousness of guilt. But I think to go further and essentially get into a debate about what the defendant claims were the reasons, I think is a bridge too far for this particular instruction. So we would ask that the court adopt our proposed instruction.
Attorney Schoenauer.
Well, as Your Honor will note, in my Roman numeral 10, I indicated at the top that I didn't agree that in this particular case that consciousness of guilt should be given, and there are a couple of reasons. In this case, it's too confusing. If you read the consciousness of guilt in cases, it's either there's no question that there was conduct that was undisputed, whether it could infer the consciousness of guilt from it or not. Either it was flight, it was personally destroying something, it was statement trying to influence another witness, tell them to lie to the police or hide something or throw something away. There was no dispute as to what the conduct was. My concern, and the way if the court's going to give an instruction, is it's not clear from the evidence that anything was stated falsely, whether it was a mistake, whether it was actually accurate, whether she was fed information that was untrue and then adopted it, and therefore sort of acknowledged or agreed with the officers that, and if Your Honor will remember in that third interview, when they asked her, if the question that is asked, I think by Detective Clabby, is, was that a lie or was that a mistake? And her answer is, well, I wouldn't call it a lie. The state assumes that must mean it's a lie. So we have all of these problems, if you will, with whether or not there is even evidence that would constitute what I would call either interfering or obstructing evidence. The concept, a person runs away from the police, the person tells someone to lie, a person bribes somebody. All these are things that, if proven, nobody would dispute whether or not they were evidence of maybe a guilty conscience under that circumstance. My point being, and I think State versus Pugh, the case I cite, is the one where there's multiple interpretations of what the defendant in that case did, but it would be more like the concept, I think, in Pugh, they talk about, well, flight. You know, if a bunch of people run away when the police show up, you know, let's say it's a drug case, that doesn't mean they're guilty of the drugs. It means they're just running away from the police, so it's ambiguous. So, you know, I wouldn't call it marshaling the evidence. Something that turns out to be false, that's consciousness of guilt, any more than when the court gives the instruction on credibility, people might forget things, you know, it doesn't mean that any witness who testified falsely because they may be inaccurate, any more than we demonstrated that, you know, use this as an example, Detective Kimball admitted that some of the things he had previously sworn to turned out to be false. That doesn't mean you get a consciousness of his guilt instruction. So I'm just pointing out that it's not a clear-cut matter, and that's why if the court is going to give an instruction, it has to be more nuanced. There has to be more detail given to it, because otherwise the suggestion is, as the state has inferred throughout, oh, she lied. So that's why I'm asking that it not be given, because it's too difficult to really give that kind of instruction here without explaining all these other reasons why any testimony was not necessarily, any statement rather was not knowingly inaccurate.
Again, because this is the first time that a charge conference has been live streamed, the court is going to take some pains to explain how it proceeds in the charge conference. The court is under no obligation to accept the proposed jury instructions of either party. What the court attempts to do in a charge conference is determine which instructions will be correct in law and find their basis in the evidence that was presented. And the court will also hear counsel on the court's next concern about a consciousness of guilt instruction. The boundaries of consciousness of guilt seem to this court to be somewhat amorphous. And the court does not want to try to firm up what seems to be amorphous boundaries, because the court puts itself in a position where it may sound like it is marshaling evidence in order to give those boundaries contour and definition. So the court is not inclined to give a consciousness of guilt instruction. However, the court believes that instructions on credibility and inconsistent statements will encompass the spirit of a consciousness of guilt instruction. The next concern the court has about an instruction it did not include in its original draft was a third-party culpability instruction. The court is concerned about that instruction because this was not a textbook third-party culpability defense. So the court will hear first from Attorney Schoenauer.
Thank you, Your Honor. The reason I'm including this is because the way that the state charged in count one, it specifically states that did agree with Fotis Dulos and other persons. Now, I would argue that perhaps what the court would need to do is realize that the only evidence the state put on was that or attempted to show that Fotis Dulos himself committed this crime essentially on his own, ignoring the evidence such as where was, let's say, Pavel Gumieni, what's going on with Kent Mawini, The fact that I think that it is now fully established that it's Jennifer Dulos's phone that connected by Bluetooth to the Suburban at 2:56 p.m. in the afternoon, when the state claims and agrees that Fotis Dulos was back in Hartford. So there's obviously other, in my view, at least the evidence shows, there's at least one other, or maybe more people involved, but it wasn't, there are all these things that are happening that it couldn't be Fotis Dulos himself, whether it's Kent Mawhinney in the office, whether it's Andreas Toutsiardis in Greece. The evidence has indicated there are others that participated in a scheme, at least on its face, there's factual evidence with Mr. Dulos that did not involve Michelle Troconis. And that's the reason that I'm asking for that instruction. If the court were to remove from the order that the language from the instruction be stricken, that there were other persons, and I had asked for a bill of particulars, how do I defend against these unknown other persons? But if you remember, before we started, I think it was Attorney Manning said on the record the other known conspirators were, and she named Mr. Gumieni, she named Mr. Mawhinney, and I believe, I can't recall if if she named Toutsiardis as well. She didn't call them co-conspirators. She used a different term. And I don't remember at the moment what it was, accomplices or evidence of accomplices, but it was during one of our online motions hearings. So the way I look at this, Your Honors, either the information has to remove other persons completely, and then it's all about just whether she conspired with Fotis Dulos.
Yes, Your Honor, we do object to that proposed instruction. Firstly, I'll just note that in order to get a third-party culpability instruction, the defense must raise more than bare suspicion, I believe is the language from our case law, or mere suspicion. And essentially asking questions like, where was this person? Where was that person? This could somehow generate reasonable doubt is nothing more than bare suspicion at this point. There's no direct evidence that anyone else participated in these crimes. It's all conjecture and speculation on the part of the defense that somehow a phone connection is conclusive proof that someone else was involved, when there was no technical evidence to that effect that they introduced. Could have just connected because it was in the woods nearby, for all we know. So I would object on those grounds because I don't think they've made that a sufficient showing. Also, Your Honor, with respect to the conspiracy count itself, we just need to prove that she conspired with one or more persons. And so whether or not other people were actually involved, so long as she conspired with Mr. Dulos, which we did plead, she would be guilty of conspiracy if the jury finds all the elements beyond a reasonable doubt. So I think it's not an appropriate request because they have not raised more than bare suspicion, and also the way it's charged in the conspiracy count, I don't think necessitates such an instruction.
Well, if I may just respond, then I noticed that Mr. McGinnis did not address the and other persons. So it is alleged that Michelle Troconis agreed with Fotis Dulos and other persons. So if the state is, by what I hear, acknowledging there is no evidence of other persons, then that language has to be removed from the information. Moreover, Detective Kimball testified that Kent Mawhinney was charged with conspiracy to commit murder in this case.
So if counsel has a case, I'm happy to look at it, but I haven't heard one.
Well, in this court's view, the third-party culpability instruction is not warranted by the evidence. Conspiracy to commit a crime with other unnamed co-conspirators, it appears under the defense's view, would always require a third-party culpability instruction. The court does not believe the law supports that proposition. Third-party culpability requires more than others were involved. It requires more than inferences raised on cross-examination that the defendant was not involved. So the court would decline to give a third-party culpability instruction. The next instruction, hindsight bias. Court will hear from counsel.
Yes, Your Honor. This is the thrust of the defense's defense. And I believe the Connecticut cases say that a defendant is always entitled to get an instruction from the court as to what the defendant claims. And hindsight bias is mostly in civil cases, but we cite at least one such case that talks about, often they're in malpractice cases or in other cases where the defense is, well, at the time they didn't know, and that's the thrust of our defense in this case.
Your Honor,
Yes.
so Attorney Manning had a chance to look at Professor Loftus's testimony when we received this instruction early this morning, and the word hindsight is not used at all. So I don't think that there's any source within the evidence for this instruction. I've never heard of this instruction. I don't want to make any misrepresentations to the court, but I thought I went to State versus Lewis this morning and did a control F for hindsight and didn't find the word. I could be mistaken on that, but in any event, Your Honor, I'm not aware of any case that stands for the proposition that this instruction as constituted is appropriate. Again, it's asking the court to marshal evidence and to essentially engage in closing argument through the jury instructions.
I may respond
Yes.
very briefly that it's not just what Professor Loftus said. Several of the detectives indicated they asked the witnesses in hindsight, did anything seem out of place? I asked similar questions to several of the witnesses and they all said no. So if we're talking about what the jury is seeing in current time with everything marshaled by the state versus what was known at the time, that is the basis of our defense in the case. And the cases such as Havocan and Lewis, they don't talk about hindsight bias. They talk about the right to have the judge explain to the jury what the defendant's defense is, other than she didn't do it.
Obviously, he can argue that, Judge.
Well, the court's view is hindsight bias is, first of all, a term that is new to this court. Secondly, if the response, as the court remembers the testimony, was always looking back, there was nothing that would have been an indication as to certain activity. Well, then the fact that in the first instance, there was no indication, it would seem to be a tautology to say that in the second instance, also there was no indication. So the court is not inclined to give an instruction on hindsight bias. Evidence of presumptive blood tests, specifically the KM test.
Yes, if Your Honor will recall, the court, there was a lot of debate on that issue. The court read some cases, and then the court said the court would allow it in for a limited purpose to show why the police did what they did. Since then, there's been so much talk in the last several weeks about luminol and KM and presumptive testing, and the court only needs to go back to State versus Moody that specifically that case said it has no evidentiary value whatsoever, and the word whatsoever, I believe, is in the decision. So the purpose of this is to remind the jury that if evidence was not tested for blood, then it cannot assume or conclude that luminol or Kastle-Meyer testing was blood. It took, I think, until the scientist, I think her name is Anna Valonis, who finally admitted that these presumptive tests only indicate the possibility that blood is present. And until that point, they kept repeating likelihood or the likely presence, and then said, well, that just means it's possible. But I would rely on not just those facts, but Moody to make sure that the jury understands. And it's also to limit any misconception that the jury might find that they would think that those KM and luminol testing were in fact evidence of blood when they're not.
Yes, Your Honor, we object to the proposed instruction. So again, this is now This was probably the first week of trial or so. And so again, I don't want to misstate anything here, but our recollection, and we talked about this morning, wasn't that the court let it in for just the limited purpose of showing the actions that the police took. The court reviewed all the case law and said that KM testing in and of itself might not be relevant, but in the totality of all the evidence, it could be relevant to the case. And so that's our recollection, that the court wasn't letting it in for some sort of limited purpose, but and by the instruction, use of the term so-called, it's inherently unreliable. Again, they're asking the court to essentially marshal the evidence and engage in closing argument for them. What the gravamen of that evidence, Your Honor, is that all these presumptive blood tests, or not all of them, but the vast majority of them, subsequently tested positive to be a single female contributor that was consistent with the toothbrush. And so the idea that these have no reliability whatsoever, when we understand that there was a blood pattern expert that came in and testified consistently that this appeared to be blood, they end up being tested presumptively for blood, and they subsequently come back to the jury. I don't recall the court handcuffing the state in terms of how that evidence could be used by the jury. And I would ask that the court not marshal the evidence for the defense. If they want to argue that on cross-examination, they pointed out through different witnesses, and my recollection is Detective Riley even admitted it's simply a presumptive test. The lab referred to it as a screening test. If they want to argue that this wasn't blood, or there's no proof that it's blood, they can make that argument, I suppose. But I think it's fair for us to make the alternative argument, which is that it's presumptive blood test, comes back to Jennifer Dulos repeatedly, and it looks like blood. So
That's exactly what I believe Moody said that could not be done. The fact that there was some DNA, it was just as likely it was skin. There was no, the only confirmatory tests that were done were on 2 items of clothing and 1 other item that I don't recall at the moment sitting here what it was. That would be an improper inference that this was all blood. And that is why the Supreme Court, the case that the exception was that an expert assumed it was blood for purposes of that expert's testimony. In that one case that Your Honor was cited and mentioned as why it would be allowed in, but it was to indicate why the police did certain things. For the state to argue that they can infer that because the DNA was found, that meant it was Jennifer Dulos's blood would be not only confusing, it would be a false inference, and I would submit would be particularly prejudicial under the circumstances.
Well, the court's recollection of the evidence is that the cross-examination was sufficiently strong concerning presumptive tests, screening tests. The lab experts' testimony concerning presumptive tests, well, the lab does not use the term presumptive, but screening. So if there was no on presumptive blood tests, so the court declines to give instruction. Attorney McGinnis.
yes, Your Honor. This is from the pattern instructions. We did put forth through the specifically not only her police interviews where she referred to the last years of her life being 2 years of torture, but also referred to Jennifer Dulos in disparaging terms, which I'm not going to repeat right now. The fact that she was disappointed over the ongoing custody dispute, the fact that she was going to be potentially moving to Colorado, as early as June 10th. And pattern instructions told me to. If the court doesn't wish to include the brief statement of facts, because it would be, doesn't want to be even the chance that it be perceived as marshaling the evidence, to that being removed. But I do think that there's a sufficient factual basis for them to at least get an instruction on motive. And I would add also chooses to reject the state's contention of motive. That could be evidence, I guess.
May or may not raise a reasonable doubt. I believe that the language, the proper language is if there's no motive, it might in fact raise a reasonable doubt. But so when I hear balance, that's certainly not the way it's written. Your Honor, with regard to the fact that the state is saying that because the divorce was negatively impacting her relationship and therefore she's going to murder her boyfriend's wife. Just if that is considered motive, then I guess moving to Colorado would need to be included in there. The fact that there was a light at the end of the tunnel, that everyone who knew anything about what was going on in the court was saying that things were favorable for Fotis, all of that would need to be in there. I would ask that the court not give this instruction, and certainly not in the one-sided suggestion, which is, particularly tenuous. And, she doesn't like that there is her relationship is being negatively impacted and the quality of her life. Nowhere is there evidence of that. She did say that the dragging on was I think in the language of the interrogation, I think she did say it was like torture, but the other evidence shows that it was ending. Everyone was happy. To give that instruction.
Judge, I just want to add that I've prosecuted cases where people have murdered for far less than the motive that we've presented in this case.
The court is inclined to give an instruction on motive. The court will fashion evidence. Those were the primary concerns of the court. Now, the court will indicate that because there are conspiracy counts, the court, in trying to make the instructions as clear as possible to the jury, wove the substantive counts into some of the conspiracy and accessorial instructions. So when we return, the court will hear counsel on the substantive charges. The court's main concern is to make those charges, the instructions to the jury, clear. Because
I'm sorry, I didn't mean to interrupt.
Because by themselves, the instructions
Would the court at this point entertain at least some of the things that the court may want to consider before included, which I don't think the court should include?
Well, that's a different discussion that should come up after we come back from break.
Okay.
So the court wants to give counsel an opportunity to review the revised instructions. Let's return at 11:30.
All rise.
Duties upon retiring. So assuming that those are standardized, those are the ones I didn't get a chance to look at before you just came back on the
Thank you.
record.
Those are standard. This is how the court intends to proceed. The court is going from just first indicate the topic and they would like the court to consider. The court is not inclined to entertain unless it affects materiality, syntax, but
Does that include, so for example, there are a couple of prepositions missing, an article?
oh, that's that grammatical errors. We can take that up.
I was going to say, you'd want us to at least bring that to
Yes.
its attention. Okay.
So court is not certain that, well, we'll start at page 1, the function of the court and jury. Material, court will consider it.
I have nothing, Judge.
Nothing from the defense. criminal statute, then it has to apply to each and every element.
So what the court will do in this instance is strike the second sentence on page 8. The law requires 2 types, and strike the second paragraph concerning general intent.
Page 9 is when the court does say what the defendant had intended is a question of fact for you to determine. And I added that, like all other elements, must be proved beyond a reasonable doubt.
I don't have an objection to that request.
Page 10, evidence of intent.
I have nothing.
I think the bottom paragraph there refers to general intent in there, and therefore, once we've taken that out, that whole first sentence there, I would think, needs to be revised, because it talks about you may draw meets the standard it has to meet. So I think that was either general or specific intent. So as jurors, you may draw reasonable inferences as long as the inferences meet the standard of the definition of intent.
Well, this is evidence of intent.
Right, but I'm talking about the last, I think the way it's written, it talks about meets the standard it has to meet. Well,
As explained with the instruction on, which we haven't reached yet, on circumstantial evidence.
oh, I see. It refers to an instruction. I get it. Okay.
And then direct and circumstantial evidence.
The only thing I noticed, Your Honor, is in the second to last sentence on page 12, there should be a period after the word evidence, and the next letter, if,
Yes,
is at capital.
thank you.
I have nothing, Judge.
On page 13, this is just for the record, the court indicates down towards the bottom that the state does not have to prove the exact location of the offense, but consistent with my argument about vicinage and the constitutional right to be tried where the crime is alleged to have occurred, I would object to the use of the word location. I certainly agree that the state does not have to prove the exact timing.
Thank you. The court will leave that instruction intact.
Oh, I'm sorry, and Attorney Felsen pointed out in the previous sentence, where it also mentions location, it says of the offense. It should say each offense, since the locations are different in several of the counts.
So which sentence is that?
The one that begins, as you will see.
Okay. Each count and the information contains the date and location of the offense.
Time, and that's why I would ask that the word each instead of the offense be substituted.
So the court is not following the proposal. Are you talking about the last sentence on page 13?
No, the third to last sentence, the one that begins, as you will see.
So the
Each
court,
count,
yes, each count in the information contains the
I have nothing, Judge.
Nothing from the defense.
Right not to testify.
Nothing from the defense.
Nothing from the state.
Impeachment inconsistent statement. The court thought about that, and the court thought that the court would do that.
Sure.
So in this court's view, it's safer to keep it blank and let the jury determine who were experts in their view.
Sure. Other than that, I have no input on that instruction.
Also, the court did not read all of the names.
We included them, but understandable position on that.
Stipulations. Defended.
Nothing, Judge.
Nothing.
Immunity.
Uh, Search this issue.
Um, yes, StreamYard has just been having lots of issues. I can't blame it on the source. I don't know why. I will be going to the James Brenner hearing. Um, very much looking forward to that. Yeah. Okay. Let's get this started again here. We've got just under 1 hour to
Points
go.
that gives some guidance on things that they can consider when determining whether or not Pavel Gumini has phrased immunity of witnesses' testimony may not be used against him in any subsequent criminal proceeding. He was actually granted transactional immunity, so he just simply can't be prosecuted. It's not just a matter of. So I would ask that the court 3. And we think it appropriately balances the interests of the state and the defendant when evaluating Mr. Gumini's testimony.
May I just have a moment to look at his instruction? I certainly agree. This is transactional immunity, which is highly unusual. So I had added a sentence. He will not be charged with any crime related to criminal conduct. Implied.
Given the contested nature of whether or not Jennifer Dulos is deceased at some points during the trial, it might be appropriate to add the proximate cause instruction.
Where should I begin? First of all, I disagree that, the problem with approximate cause instructions, there has to be some underlying facts that would necessarily lead to that, and everything remains a mystery in that, crime had to be intent to kill, that there was an intention to cause the death of Jennifer Dulos, and in fact, her death resulted, which are the actual elements. So I would the paragraph before murder as it does in the conspiracy is. I agree with Mr. McGinn. Is Charles Jennifer Dulos with the intent to restrain and kill her? Part of the problem is they've charged it that way. I think the court needs to put it in that way, and if they have failed to present evidence of it, that's their problem.
Okay, that concludes that. And tomorrow we will have closing arguments and the jury will start to deliberate. And we'll, while we're on verdict watch, we'll do the Rust trial, and we'll see you tomorrow. It should be good. Bye-bye.